the chamber and partners, and the IFLR 1000 as a leading lawyer in the region. Mr. Kirago has previously been awarded the International Law of His Client Choice Award as the best litigation lawyer in Kenya. Let's give him a clap for that. How many of you can say that about themselves? But we are getting there. That's where we are heading. Mr. Kimani is also highly rated by his clients. Many of them come back and say, we have received excellent support. He's been very sharp and dynamic. He's been very flexible and very commercial.
Very commercial?
Yeah. Martin says yes, very commercial. I hope it's the commercial in the positive sense. These are the areas of Mr. Kirago's practice: dispute resolution and litigation in the areas of public procurement and PPPs, tax insurance, arbitration, intellectual property, aviation, medical negligence claims, libel, building and construction, and real estate. His qualifications: he was admitted as an advocate in 1988. He was in the School of Law between 1987 and 1990 for his bar finals. In 1984 to 87, between 1984 to 87, Mr. Kirago was at the University of Nairobi for his bachelor's degree. He is a partner. He has been a partner at HHM since 1991. Before then, 1988 to 91, Mr. Kirago was a legal assistant at HHM. That's quite a mouthful.
That's his presentation.
Martin says that is his presentation. So I think we shall put our hands together and invite Mr. Kirago to add on to that. Thank you very much. Karibu Bwana Kirago.
There's at least 7-8 people who I work with who must be wondering who they were talking about, because they don't recognize any of those things. He also mentioned that for people like us, the rural-urban case is not something to remind us. Not a very polite thing to say, to remind people who are Noah's Ark, ask them what exactly was a flood like, because this goes back 31 years or 32 years. And if you were an adult then, you're probably being looked at as a piece of furniture by now. He went on to say that there are many overlaps between what the various speakers have said. I agree with that, and I will therefore try and keep it very short, because every time I put on a slide, I'll say, I'm sure you've heard that, and it will probably be correct. Having said that, like every court lawyer, we're not particularly famous for keeping time. So although I see I've been allowed 45 minutes, I rather suspect if I get to 30 minutes, I'll be lucky to have 10% of the people in the room. So I'm going to suggest if a kind soul, when I start getting to half an hour, could raise their hands. And I suggest this be done by somebody at the back so that I look clever and like a good manager. So these are the guys don't see. If you put up your hand, then I'll know it's time to wind up. And just
the
to
hand will come from right here.
To finish up with my introductory remarks, unlike Martin Olo, I don't have an LLM. I don't hope to have one.
You don't need one. He doesn't need one.
I am not a candidate for a PhD. The only candidate I look forward to is the one at the bar this evening. There I have to say I do as well as any Queen's Counsel. And finally, to turn to Mr. Kamau, he suggested that I should tell you what complex tax disputes are, because those appear in my CV. Well, the short answer is when a client walks into your office and he says, I know I owe, lakini sitaki kulipa, that's a complex one. Your job then is to get them out of trouble. Of course, always remembering that your first and most important duty is fidelity to the law and to the cause of justice, not to create cases. Well, let me start by thanking my colleagues in the office who've helped me prepare this. Their names are there. One always assumes that the person, what you see, what you hear in here is the beginning and the end. What we must always remember is that a lot of hard work has gone into this. And I don't know whether the slides are always shared. I hope they are. And I look forward to a day where when people like me are a little better organized, these slides will be shared before, so that people can read these things, do some of their own reading, and then we can have a more meaningful engagement. What do I want to do this afternoon? I want to do 3 different things. The first one, I want us to just have a look at the entire process of winding up, and in doing this, under the Insolvency Act, I'll be looking at 3 different things. We'll be looking at members' voluntary winding up, creditors' voluntary winding up, and then a liquidation by the court. Then I want to look at the comparison between the old regime, that's the Cap 486 regime, and the Insolvency Act. I will also, thirdly, look at a few salient features of the current regime that's under the Insolvency Act. Straight into it then. Now we have the Insolvency Act in place. The insolvency regulations weren't in place for a very long time. What do? These two actually now consolidate the law relating to insolvency. And when we're talking about insolvency, please remember we're talking about natural persons. That's we human beings. And then we're talking about artificial persons, incorporated and unincorporated bodies. We're not going to be looking at natural persons. And again, even when we're talking about incorporated and unincorporated bodies, there's different facets of this, some of which I'm sure my colleague Noella has looked into. It's not just liquidation. You have different animals introduced by the Insolvency Act. Conversation for a different day. You've got administrative receiverships, you've got CVA as a company, voluntary arrangements. You no longer have receiverships per se. You've got an animal called administrative receivership. But again, as I said, that's not for us to discuss today. We're just going to focus on the winding up procedures relating to incorporated and unincorporated bodies. Simply put, liquidation is just a process of ascertaining the liabilities of a company. And once you've done that, you apportion the assets of the company towards the discharge of the liabilities. And the final thing is you dissolve the company. So 3 things: you ascertain, you apportion, and then the dissolution is a final nail in the coffin. As the name suggests, liquidation is really just winding down of a business. I probably should have said when I was talking about an LLM and a doctorate is, you will have seen from your program that this, and I am not being cynical here, this learned gentlemen were given more complicated topics to talk about: key concepts, parameters, circumstances, and grounds. That was for Mr. Martin Olo, soon to be Dr. Olo. Please, I am not being cynical. I have utmost respect for learning. Then Mr. Benjamin Musau had the pleasure of speaking about salient features of the Kenya Insolvency Act 2015, a practitioner's perspective. Mine is very simple: winding up.
And you're doing it literally.
And at that point in time, you should tell me, are you done? Because I'll say I'm winding up. Okay, back to business. Now, liquidation may either be, there's 2 broad categories: either voluntary or by the court. And even for voluntary, there are 2 different animals here. You've got a member's voluntary liquidation, and you've got a creditor's voluntary liquidation. It sounds a bit like a misnomer that it could be a creditor's voluntary liquidation, but it's something we've picked up from other jurisdictions. But when you look at the Act, you will see, what is intended. Now, members voluntary, and I'd urge you when you're back at work or those who have your laptops, your phone, you can look at Section 382 of the Insolvency Act. It does set out the distinction between members and creditors' voluntary liquidation. But broadly speaking, a member's voluntary liquidation refers to a liquidation in which the directors excuse me, have made a statutory declaration pursuant to Section 398. And this doesn't have to be done on a creditor's voluntary liquidation. Now, strictly speaking, under the old regime, when you spoke about liquidation, there was still an animal called a voluntary liquidation. But by and large, what was referred to was a liquidation through the court process. But that's changed. I think if abolished is a bit of a strong word, probably not the appropriate word, because you still have the liquidation by the court. But the message I think I wanted to convey is that we really have shifted from where we were. And one of the things I should have said right at the start is that the general thrust of the Insolvency Act is to migrate from the Cap 486 situation, which was the first guy to breast the tape actually grabbed it all. In other words, you had a certain hierarchy, certain pecking order. What the focus now is on is to try and equalize as many, as all the creditors as far as possible, and we'll look at that in a short while. Now let's just look closely at the members and creditors' voluntary liquidation. But precursor to that is, on what grounds can a company be voluntarily liquidated? There's a number of grounds. I don't intend to walk you through all of them. Some companies are set up for specific purposes, to do a particular thing, to develop a particular housing estate, period. When that happens, then the company is ripe for liquidation. Second ground is where the company has passed a special resolution to go into voluntary liquidation. And there are rules for that. When you do that, when you pass a resolution as a company, then the resolution has got to be published within 14 days of its being passed, once in the Kenya Gazette, and once in at least 2 newspapers in the area which the company has its principal place of business. Now you can see a typical cut and paste job. This is not United Kingdom, where you have Manchester has its own newspapers, London has its own papers, and then you've got a few national papers. Here you are unlikely, you'll have a few vernacular papers in Kisumu, in Kiambu, and such places, but you're unlikely to find these notices published there. But this is a cut and paste job from the UK. That's why you have the localized bit as well. And then an attempt to embrace technology on the company's website. Again, I urge you to frequently look at the papers, because for those of us who are litigators, and not just litigators, even for the other practitioners, it's always important to know, as you're preparing your documents, what's the status of the other company. If it has passed a resolution to go into voluntary liquidation, this is something that you should know about. This is something you should advise your client about. And there are things that have to be done before the resolution is passed. This, again, is not entirely new. A declaration of solvency. It may not have been called the same under the under Cap 486, but there was something akin to this. And this has to be made within 5 weeks preceding the date of the passing of the resolution. It doesn't mean what is sought to be achieved here. You don't want to pull a fast one on creditors, on some members by passing a resolution in January, making a declaration of solvency in January, and then passing a resolution in December. It's got to be within 5 weeks before the passing of the resolution. Then a notice of the resolution to liquidate has to be sent to the holder of a qualifying floating charge in respect of the company's property. So again, if you're advising a company which is walking down this path, they've decided we want to go into liquidation, you should have your checklist. What are the things that we have to do before we get to the resolution? What are the things that have to go into the resolution? What follows after this resolution has been passed? And that's part of what is on your screen now. After the expiry of 5 days from and including the date on which the notice is given, or if the person to whom the notice is given has consented in writing, please note that the holder of a qualifying charge can actually consent. Then the notice is taken effect. When does the liquidation process itself commence? Sections 393, 395, and 396 have to be looked at closely. But the bottom line is that the liquidation commences with the passing of the resolution to liquidate the company. It's important to note this because if you're preparing security documents and the liquidation process has commenced, these will be affected. Again, all the more reason to keep a lookout in the newspapers. Any sensible practitioner in this day and age should have either a librarian who's a specialized person who goes through their papers on a regular basis, or a trainee lawyer. I know there's many of us who actually believe having a trainee lawyer in your office, these are your pupils and interns, is an unnecessary expenditure. It isn't. These are the sort of tasks that they can undertake on your behalf. We as practitioners will not be able to do this on a day-to-day basis. Yet, it could be very expensive for you preparing security documents and later discovering that a resolution had been passed to a company to go into liquidation. It has taken effect, and you have gone and created securities over its assets because you are not going to be doing your client anything other than a disservice. What's the consequence of the commencement? A couple of things. First one is that the company ceases to carry on business. There is a rider there, of course, if it is necessary for the beneficial liquidation. What examples come to mind? Maybe a company's sole business was to develop a housing estate. And 90%, 95% of the work is done. There's a few units left to go. The directors consider, the members decide that they need to go into liquidation. We've achieved the objective. It may still be advisable for it to continue in business to complete the remaining units, sell them, because that's clearly beneficial to the liquidation, collecting all the assets. As we saw, there are three different aspects. Okay? There's a couple of cases, English cases on this, which in the fullness of time you can look at. I imagine the Secretariat will be sharing the presentation. The second consequence of the commencement of the liquidation is that the corporate status and the corporate powers continue to have effect until the company is dissolved. And we'll come to dissolution a little later. So don't let anybody tell you that now that it has commenced, the corporate status or the corporate powers have come to an end. It is not correct. Thirdly, share transfers and attempts to alter member status after the passing of the resolution are void. I have to emphasize, however, and there's good reason for this. You don't want people allowed to transfer their shares when the company has already passed a resolution and in effect the liquidation has commenced. But there is an exception. I think the liquidator may allow transfers. He may consent to that, or even alteration of a member status. And it makes perfect commercial sense. You know, you may be after a judgment debtor whose sole asset is a stake in a company which is going into liquidation. You've got your back against the wall as a decree holder. If that's the only asset, then it would be most unwise for you not to accept to take a transfer of the shares, subject to confirmation or approval by the liquidator. You at least have something to look to make some sort of recovery for your client. Now, thus far, these two creatures, that's the members' voluntary liquidation and the creditors' voluntary liquidation, they're by and large the same. A divergence starts to appear at this point in time. So let's start by looking at the members' voluntary liquidation first. A number of things. First of all, for the members' voluntary liquidation, it is a general meeting of the company which appoints the liquidator, and could be one or more. and please note the use of the word shall. They're the ones who have the responsibility, the mandate of appointing the liquidator. Second thing is that after the appointment of the liquidator, then all the powers of the directors come to an end. But the company in general meeting or the liquidator can actually allow the directors to continue exercising their powers. Again, my example of the company developing a housing project. The business may very well rely significantly on the goodwill of the individual directors. It would be foolhardy for the liquidator to tell them you're done, you're out, now that the liquidation process has commenced. You may want to take advantage of their goodwill to complete the business. Okay? Third thing, this is common to both of them, only an authorized insolvency practitioner is eligible for appointment as a liquidator. I'd urge you, when you have a little time, to look at sections 6 and 7 of the Act and regulations 11, I believe it is, as to who is qualified. I think we've got a through pass as lawyers. I'm certain that we as lawyers do not have to sit any sort of exams. We've got an opportunity here to get into a space that has been the preserve of the audit firms. We must always look for growth opportunities for ourselves. We always think in terms, are you a court lawyer, are you a conveyancer, are you a commercial lawyer? Here's another avenue that lends itself to you to get into business. Okay? Let's look at the creditor's voluntary liquidation. Now, the company has, first thing is that the company has to convene a creditors meeting not later than 14 days after the resolution of the company to liquidate. And at this meeting, the directors have to present the financial position of the company. Remember the members one was preceded by the declaration of solvency. This is slightly different, okay? At this meeting, the creditors may, again in contradistinction to the company shall on the members voluntary, may appoint a liquidator. This is permissive. If they don't do this, then the company will nominate the liquidator. And again, it's debatable. This talks about a liquidator. Does that mean you can't have more than one? Probably yes, but members voluntary, I think you could have more than one. I'm not sure what the rationale is, but I don't think we should be detained by that. The creditors at this meeting may also appoint a liquidation committee. What's the objective of this? It's generally to give the creditors themselves some say, some voice in the liquidation process. So especially for large concerns, it would be most unwise not to have a liquidation committee. Okay. Again, like the members' voluntary liquidation, upon the appointment of a liquidator, the powers of the director cease. But another rider, the liquidation committee, and we see again the creditors can continue to play a role in this, or if there's no such committee, the creditors themselves can sanction the directors continuing. Okay. From then on, the process between a members and a creditors liquidation is largely the same. Now, I'm going to skip a couple of slides because I'm going to have the comparative bit a little later on, and I sense that I have taken a little longer than I should have on the first bit. Let me just see where I want to stop. And again, ladies and gentlemen, I think probably I think I want to start with the dissolution, because that's the next step. Okay. After the liquidation process comes to an end, you have a final meeting, and after the final meeting, the liquidator sends a statement of account of liquidation, which is presented to the registrar. Okay. The registrar's obligation upon receipt of that statement is to register it. And again, if you look at the Insolvency Act, there's a couple of different registers created. It's important for us as practitioners to familiarize ourselves with them. At the end of 3 months from the registration, the company stands dissolved. But, and this is a big but, because frequently we will discover things have happened much long after the event, the court still has the power, either on the application of the liquidator or any other person who demonstrates that they have a legitimate interest in the matter, to make an order deferring the date at which the dissolution of the company is to take effect for such period as the court considers appropriate. I can't think of any situation this would happen, but just shooting straight off the hip, you've been instructed to file proceedings against the company. You go and run a search at the company's registry and discover that there's been a final meeting, a statement of account of liquidation has been presented, and upon looking at it, in your view as a creditor is not accurate. If the 3 months are not over, you may dash to court and get an order deferring this while you query the statement of account. I'm sure there are many other instances that you can think of, or at least a couple of others, where a person may be entitled to move the court. But again, I keep telling people, let's always not look at statutory provisions. Think about the cases that you're dealing, think about the problems that your clients are encountering. What can I make of these provisions? How can I help them? Do I just sit back and wait for the liquidation committee or the creditors or the liquidator to drive the process? Or is there a way I can get to make an intervention? Okay? Let's look at the other animal, which is a liquidation by the court. This one commences after the making of a liquidation order by the court. And then, please, Section 431 is a must read. You cannot go and read the slides and assume that I know it all. It's a must read. And again, because this is borrowed from the United Kingdom 1986 Act, I believe it is, look at the case law on this. Investing in, there's books out there. I keep telling people we don't spend as much on books as we should. There's no excuse for that, especially for those like me who are going to be sitting behind some counter this evening. Just consume a little less and buy a book. All right. Now, once the liquidation order has been made, then all the legal proceedings against a company which have been started can only be, or if you want to start proceedings, this can only be continued with the approval of the court. Again, it's important that we keep our eyes open, because if a company is in liquidation, you're going to be in trouble instituting proceedings without the approval of the court. You're going to be risking your action being struck out by the court. On what grounds can the court liquidate a company? Some of these have survived, Chapter 486. Let's fly through a couple of them, where there's been a special resolution that the company is to be liquidated by the court, where a public company that was registered as such has not done certain things. It has failed to issue a trading certificate, and these are cumulative. More than 12 months have elapsed since it was so registered. A couple more of these: the company does not commence its business within 12 months from its incorporation, or suspends its business for a whole year. We don't need to look at all of these. Just for number 5, I'd like to pose it for one moment. You could wind up companies for debts of 1,000 under the old Act. I think it was Section 401, where you issued the winding up notice, or 220, one of the two. This has gone up to 100,000 shillings under the Insolvency Act. Okay, probably still on the lower side when you consider the expense that is incurred in the liquidation process. If you remember that you have to place a number of advertisements in the media, 100,000 looks like something on the lower side. But again, the other side of the coin is that even if the debt is low, there may be an important point of principle in liquidating a company. All right? I don't think we need to look at that. Maybe 7. Just and equitable was a fairly popular one under Chapter 486. All these old companies, Yeniji Rubber from 1912, are still good law. You still can't come under this. And again, no excuse for not familiarizing yourself with these provisions, especially if you're a litigator. Who can move the court? A company or its directors, a creditor. And please note that a contingent creditor can move the court. Liability has been established. The quantum of damages has not been determined. You can actually go to court and say, I'm moving the court to liquidate this company. Okay? A contributory of the company, a provisional liquidator or administrator. If you remember right at the start, I said there are other things that have been introduced by the Insolvency Act, like the CVAs and the administrative receivers. These people, these offices which are created, these are people who can also move the court for the liquidation of the company. The AG has been given some powers. I want to fast forward to some of these. Forget things like a trading certificate. Those are fairly straightforward. But again, we are trying to transition to a fast world, or not, if not necessarily a fast world, to bridge the gap between us and the larger economies, where the Attorney General has some teeth. All right, he gets information. Look at B, for example. He gets information after investigations by the Capital Markets Authority or the registrar that certain things are not right. He can move the court. Okay. He gets a report from an inspector who's conducted an investigation into the affairs of the company that is pointing in the direction of liquidation. Again, he can move the court. For those who are in the Attorney General's chambers, for those who are representing persons who are unhappy about the state of affairs in the company, these are opportunities for us to approach the Capital Markets Authority and tell them, I represent X. X has certain concerns about company A. These are the concerns. We now ask you, pursuant to section 425, to look at these complaints and consider making a report to the Attorney General. We have to always look for new opportunities for ourselves. Okay? What can the court do once it's had an application for liquidation? Primarily 4 things. It can throw out the application. It can put off the hearing conditionally and unconditionally. Now, one might say that doesn't resolve the matters, but we have to remember all the time that it's putting it off because it expects certain things to be done or certain events to take place. So it's not as simplistic as it appears. A judge may be persuaded that if I defer this to a later date, then certain things could happen which will change the landscape. It could make an order for an interim liquidator to be appointed, or it could actually tailor-make its own order, depending on the circumstances of the case. Again, it's for us as lawyers to be creative. Don't just go to court and the judge asks you, well, what do you want me to do? It says, any order that you deem appropriate. You're not doing your client any justice. Read up in the books, and you look at a lot of these cases, you'll get great ideas as to what you can ask the courts to do, and fashion your orders in a way that the judge will see, right, I've understood the facts. I've seen this guy has a roadmap to where he wants to go to. Is there any reason I should not follow his roadmap? You're doing justice to your client's case, all right? Again, the court may appoint a provisional liquidator, either at the time it's making a liquidation order or even before. Take advantage of this. You, as a creditor, want to move the court to liquidate a company. You are concerned that in the intervening period, the assets of the company could be dissipated. The directors could mischievously put the assets beyond the reach of the liquidator when he's appointed. You can ask for provisional liquidator to be appointed. We had something like this under Chapter 486, but again, it's for us to take advantage of these provisions and help our clients. Move the court, look at what has been done in other cases, okay? I want to skip this. We're running a little behind on our schedule. Let's just look at generally what the role of the liquidator is. Within 7 days after a liquidation order has been made, the company itself has to lodge a copy of the order with the registrar. And this order is registered. It also has to lodge the order with the official receiver. And please remember, overlooking some of these steps could have significant consequences for your client, and you could have your work all undone at a later stage because of missing out on some of these things, okay? Upon the making of the liquidation order, the official receiver becomes the liquidator of the company. And he continues until some other person is appointed in the creditors or contributories meeting. I emphasize that it is our job, if you're acting for the petitioner, if you consider that there is a lot at stake, then you must be prepared to advise your client to incur the expense of having somebody other than the official receiver appointed the liquidator. Why? Because this person is going to be able to dedicate greater resources. Remember, the official receiver is dealing with all these things that are happening relating to companies. So if you want, and I don't mean any disrespect to the official receiver's department, if you want a thorough job done, you'd be well advised to consider having somebody other than the official receiver appointed the liquidator. Okay, the functions of the liquidator include ensuring the assets of the company are realized and distributed to the company's creditors. And then if there's a surplus, to distribute them to the persons entitled to them. Again, and this is, I said I'd come back to this, what's the pecking order? The first thing is that he has to ascertain the debts, the liquidator. Once he's done that, and he then has to distribute the assets which are available for the payment of creditors. And you must look at the second schedule of the Act to establish how this is done. Okay? Very quickly, this is the order of priority. Expenses of the liquidation. Perfect reason for us to be insolvency practitioners. You're going to get paid fast before all those poor souls who lent money to the company. Okay? The second priority is the employees. And then the third priority are tax claims. Now, the expenses of liquidating a company, as far as the assets of the company are available for the payment of general creditors are insufficient to meet those expenses, have priority over any claims to property compromises in any floating charge. So you are even ahead of the guys with a floating charge. Okay? If I haven't persuaded you to all go and start becoming insolvency practitioners, I am not doing my job. Okay? I am not going to walk you through the process of ascertainment of the debt. Again, look at section 474. Before we get to the swan song, there's going to be a final meeting. Once a liquidator is satisfied that the whole process is completed, he will call a final meeting for consideration of his report. And once the meeting, or the function of the meeting really is to consider the final report or the report of the liquidator, and then the liquidator has to give notice to the court that the meeting has been held and what decisions were taken at this meeting. What follows thereafter is that within 7 days of the giving of the notice to the court, the liquidator, note he's now called the former liquidator because we are at the tail end, has to lodge a copy of the notice with the registrar for registration, and the registrar has to register it as soon as practicable. At the end of 3 months from the date of registration of the notice, the company stands dissolved. Again, we have a rider. There may be people, including the official receiver or anybody else who demonstrates they have a legitimate interest, who may be able to persuade the court to defer the date of dissolution, right? Let's very quickly run through the, a comparison between the three different creatures that I've spoken about. In terms of the objective, what triggers it, the key players, and who's in control. That will help you put things in perspective. That will help you guide your clients as to when they come and tell you, we are thinking it's about time we shut down this company. Advisors on the way forward. If you have the pros and cons of each one of these, then it helps you in giving proper advice. Let's start, and again, I will not go through the entire table. Take your time when you receive the presentation and actually look at the provisions. There's no substitute for looking at the provisions. Sometimes in paraphrasing things, in trying to give them your interpretation, things may be lost. That's why I emphasize you must look at the provision. Let's just look at a couple of these. Let's look at sample some things like the objective. In a member's voluntary liquidation, it may be that the owners of the company have decided, look, we've done what we set out to do, all right? So we want to shut down this place, okay? Creditors, it may be that they feel, a creditor feels this guy is a bust. Let's start the process of shutting them down, okay? Liquidation by the court could be anything, including the just and equitable clause. And then the trigger events, I've set them out there. Key players are something you have to consider in advising your clients, because as far as possible, you want to be in control. And I use the word control rather loosely because it's not the appropriate word when it comes to liquidation under the Insolvency Act, because no one really has absolute control. Even the liquidator, you see, has to file various notices, has to call a final meeting. So there's no such thing as total control. But still, it's like being a plaintiff, choosing between being a plaintiff or a defendant with a counterclaim. They have certain advantages. So it's for you to look at the key players. In the voluntary one, it's a board of directors and the liquidator and the members. Okay. In the creditors' voluntary ones, a few more players, but again with varying degrees of influence. Okay. So that is something that you have to consider. Control, as the words suggest, members, it's a members. Court, it's a court, and creditors, it's a creditors. Now, I don't want to look at some of these. You'll find them there. I really just want to get to the tail end of this, which is a comparison between the repealed Chapter 486 and the Insolvency Act. The whole purpose of this is that we must always look at where we've come from, and then where we are and where we intend to go to. We then move to determining which cases are still good law. And remember, our advisors, lawyers, is always premised on three things. First, statute. Second, interpretation of statute by case law, all right? And together with that, scholarly text. Hence my emphasis on investing in books, okay? Let's just look at a sample of these. The forms of liquidation, you can see under section 212, and we've taken a certain departure from that in the Insolvency Act, the middle column. And again, if you look at the column with comments, the total control that the court had under Chapter 486 has in many ways been ceded. I mean, this is, I think, in some ways also reflective of where we wanted to go to as a people with the 2010 Constitution, which is giving greater control to as many people as possible. Let me just keep this and look at some key things. For example, under Chapter 486, the liability of past shareholders. You are out before the process started. No liability touches. Now, you have to read Section 386 carefully under this, because you may be gotten at as a past shareholder. So again, it's our job as practitioners. When Mr. X or Ms. Y shows up and says, I cease being a shareholder, I've now got this notice from a liquidator asking me questions, can you write to them and tell them to go to hell? It's your job not to just tell them go to hell, but to do some reading and determine whether you are entitled to ask them to go to the netherworld. Okay? I don't want to go through the notices, but the whole purpose of this is to actually have a comparative analysis. And there's a couple of things that haven't been covered. It's of critical importance that you get to understand this. One of the things that I find frequently happens especially for us court lawyers, is you find people saying this point has been settled in the case of. And the case was decided under the old regime. You haven't bothered to interrogate whether that provision was replicated in the Insolvency Act or whether it was varied in any way. It could be in some different shape or form, in which case you have to interpret the case in accordance with the new statutory provisions. So much for the comparison. I'm done. I'm sorry I've overshot the time. And the guys at the back, you are doing very badly. You didn't put up your hands. You didn't put up your hands, and I would have looked very clever. Thank you.
Can we do better than that by appreciating the presentation? Thank you so much, KK. And he's normally good in these things. And I could see the audience was following. A few people here and there were trying to pray for him, but they did not succeed. We want to do plenary, and if you promise, we'll do it quickly. If the questions are precise, state your name, to who you are addressing your question, either to Martin. I'm told he did a very scholarly work, so ask the hard questions and spare. So could you have the mic, please? Tell us your name and the person you want to answer your question. Who will start? There are some two people here. Start with the lady.
Thank you both for your great presentations. Really a wonderful learning opportunity. My name is Lydia Karaoke, and my question is to you, Kirago, and it relates to the priority of claims. And what has caught my eye is the second priority claims, the employee claims, which I think are addressed in the second schedule. And what the second schedule seems to say is that in considering the employee claims, the wages and salaries will be those for the last 4 months before the bankruptcy or liquidation. And then, of course, there'll be holiday pay, redundancy pay, and all that. But at the end of the day, it seems to say that the limit or the match that can be paid to any one employee is 200,000 shillings. So what has caught my eye is, and what I'd like you to clarify first, is what could be or might you know what the equivalent is from where we copied this law from? Because for me, 200,000 shillings, 4 months pay, that's about 50,000 per month. You haven't considered the deductions. They're saying it includes holiday pay, redundancy pay is in there. So I think the target, when we are talking about employee claims, are maybe, with due respect, the very low-level employees. So what could have been the rationale for limiting this or capping this at 200,000? Because it means then those ones who are a little more higher earning or whatever, 50,000 per month is, I think, for me, on a lower side. So if you might know what is the equivalent in the UK and what the rationale might have been to cap this at 200,000.
Thank you. The gentleman next to him. To her.
Hi, everyone. My name is Alex Kanyi, and I have 2 questions for KK. One is whether directors can resign when the voluntary liquidation process has commenced, and whether a new director can be appointed thereafter. And the other question is looking at, I believe, was it section 494.3 or 497, where we're saying after 3 months, after the liquidator's account has been presented, the company stands dissolved. I'm looking at it having in mind section, I think, 897 of the Companies Act. Do you still have to go through the process of having the name of the company struck off, or you just leave it at once the liquidator has presented his account?
Thank you. Next. Martin, you seem to have done very well. Nobody's. There's somebody at the back, please.
I'm here.
Sorry. Oh.
What I didn't get clearly.
No, I know your name, but they don't know the name, please.
I'm sorry, my name is Moibi. My question is, I needed a clarification on winding up by the court. Once the petition has been filed, if there are claims decrees against the company, are they stayed? Is the execution stayed?
You've got the question? Thank you. There's somebody at the back there.
I have a question and 2 remarks.
Short short ones, eh?
Oh, well, I wasn't going to preach, it's just a remark. My first question is a build-up on the question asked concerning the employees. Don't you think, this is, whom shall I ask? Kirago Kimani perhaps. Don't you think, having regard to the provisions of the Constitution concerning the jurisdiction of employment matters being in the Industrial Code or the Employment Code, and having regard to the Malindi decision concerning this specialized court, the way they are like, this is strictly only for these courts, don't go elsewhere. Suppose a winding up court, makes certain decisions concerning the employees' pay, severance pay, whatnot. Don't you think it is open to challenge that, that is a matter that should not have been, be dealt with by that winding up court, but rather by the industrial court, which again raises the issue, do they have jurisdiction to deal with such matters when they're in the winding up? It's one of the problems again of copy pasting, because the Constitution is different from the British one, which is unwritten. Concerning the remarks that you want me not to preach, the first thing is the remark by Law, my lecturer, that there should be, the inspector, out of abundance of caution, should try as much as possible to refer his decisions, or rather to have the court sanction his decisions to avoid needless objections. If I got you right, if that's what you said. I would somewhat object to such a, because for the reason that legally, I agree with you, practically it would be extremely expensive if you keep going to the court for your decisions as a administrator. But then also legally, because it is the court abrogating the discretion because it is given to him. But now the court is as though the court now becomes the one doing the administration, which shouldn't be the case. Number 2, again, practicability, the lower side. I think these are specialized people. These practitioners are more specialized and are better suited to make the day-to-day and then, minutiae of the winding up, as opposed to the court. So that, in fact, the court should have a very limited role where a specialized person is doing it. That's just my two pence, for my opinion. Then the second remark, to wind up, is concerning suggestions in the former session. Sorry, I'm bringing you back. Concerning amendments to the law. I am all for that. But there's something I think we as lawyers lose, and it is that what is in the law, what is in the statute books, can be totally different. The law in the books and the law in action can be two things. So that mere amendment is not enough. I think as a law society, we should be more vigilant in appointment of judges to know their philosophy, because no matter what you put in the statute books, I can always come and say no as a judge. Justice Ogola is a textualist, is a positivist, says if there is no law, there is no law. I have nothing to do with this petition. Justice Tuyot comes and says, no, there may be no subsidiary legislation, but there is a primary statute. I think I have jurisdiction. It is a jurisprudential issue. It is not who is right or who is wrong. So I think as a law society, we should be more interactive when these judges are being appointed. If indeed you want to secure your stakeholders' interest, to know what is their philosophy, how will they do it? It's not merely their learning. What is the approach to law? I think that would be a much better way than following Parliament. Because whatever Parliament passes, will come to the judge, who will ignore, sometimes outrightly, ignore what is in the law and make his own decision.
Thank you for being brief. Another person, please. There's somebody at the corner there.
Thank you very much. My name is Lillian Mwaneki. First question to Mr. Olo. When you mentioned some of the qualities of an IP, you mentioned physical and mental fitness. And I was just wondering why the physical comes in. Because I believe this is not a manual work. Second question, I think Mr. Olo, you can still address it. The issue of the liquidations. You brought in the issue of these winding ups that were done to rural urban, Pioneer, Continental. And we do know that some of these are still ongoing. They have not been finalized. And I was wondering, in the new law, is there a kind of limit in terms of time so that the interest of the whole exercise does not become one of benefiting whoever is doing that exercise? Thank you very much.
Thank you. Is somebody else here? They're increasing with the time. Yes, I can see her. She's bringing the mic.
Maybe to finish off, my name is Sally Mahiu. To finish off Lillian's question, my worry when I heard the gentleman say rural urban and others were political, some could have been politically motivated. What laws have been put in measure or regulations to stop that happening again? I panicked because it means it can happen anytime if nothing has been done through the law. Thank you.
Thank you. The last, the winding up question.
My name is Njoroge Nganga. My question is to Senior Mr. Kirau Kimani. There's something he stated and I was left a bit confused because he said that once liquidation starts, the corporate status and corporate powers continue. Now, what does that mean in relation to the issue of a company having the status to sue and to be sued? And I ask this in relation to what my learned sister, Ms. Noela, said. And she quoted the case of Karim Kuji. I didn't get the name very well. I think she can clarify. She stated that it's not necessary to do interlocutory application for stay of other proceedings once the insolvency starts. So my question is this, in that regard. Should lawyers, especially those lawyers who do many running down matters, are we going to still expect moratoriums to be published, or should we be vigilant so as to know that this company is under liquidation or insolvency and then avoid doing or rather proceeding with those running down matters? Thank you.
Thank you. Could you have the mic here? They can answer those ones and another incidental matters that may have cropped. Noela, you're also being looped into the answering. Could you start with Kirau?
Let's start with Lydia's questions. You're worried about the low cap. I can't give you the UK equivalent now, but I hope I'll be able to give it to you. I'll just try and Google that and see whether I can get it. But I think it's a shift from where we were in that they have been moved up. It may be a small sum of money, but it's pretty much like all the troubles that banks have had. It's a lower depositors who are looked after first. The guys who are entitled to up to 200,000 will generally, you will be trying to access or give access to some sort of money to the lower earning guys. It's not your MD who has been taking home $3.5 million every month. So sometimes it's a question of looking at where were we and where are we now. There is at least a shift in the position in that employees, and I have my own thinking about this as to whether they should be elevated over other people. They may actually have contributed to the collapse of the company. So why they should be rewarded before us poor creditors, I don't know. It may be low, but it's a step in the right direction. Remember, these things could always be amended over time. So I wouldn't be worried about the low cap. It's a principle more than anything else. Alex wanted to know whether directors can resign after liquidation started. I'm certain, I can't give you the provision, but I'm certain you can. But you have to remember, that doesn't mean that if you're trying to walk away from the trouble, the liquidator could still be able to come back to you and say, I want certain things from you. As to the appointment of new directors, that's one which I'm not certain about, and I'll look it up, but I do not quite, from a logic point of view, understand why you'd be appointing directors when the powers actually cease with this. Unless you are wanting to bring in certain special skills to continue the business because it's beneficial to the liquidation of the company, I cannot imagine there'll be any instances where the company will consider it's necessary to appoint new directors. Because remember, the whole function of the liquidator is to step in and take over the proceedings. And the directors can only get involved with his blessings. Okay? What's the effect of the liquidation? Is the name of the company struck off? I think, look at the different registers. I believe you'll be able to still go and run as such and find X Limited is still there, but against it, there is an entry that this company has been dissolved. Okay? The whole idea is to, at the press of a button in the future, from the comfort of our offices, to be able to run searches and to get the status update of any company, including companies that were dissolved 5, 10, 20 years ago. That's where we are aiming to be. I think it was Alex who also asked whether what happens to decrees, or was that somebody else? Anyway, bottom line is a stay is a stay. You can't allow some people, because they got there. As I said, winner takes all. The guys with decrees sometimes would be able to beat other people. There is a stay. Execution proceedings would, in my view, be caught by the provision that says that you've gone into liquidation, there is a stay. So you're not going to be able to say the rest of mankind has to wait for the liquidation process to come to an end. I can walk in with my decree and pick up what I please and sell. No. I think it was David who asked about, with reference to the recent decision on the jurisdiction of the specialist courts. I think we must always remember what each court is doing. The winding up court, in considering the priority of the creditors, is not dealing with the employer-employee relationship. It is looking into the priority of debts and how they are to be distributed. Now, last Friday, I think the Court of Appeal gave a decision which is helpful. This was a decision on the tallying of the presidential election ballots, the votes. One of the objections that the IEBC had taken was that this was not a dispute that should have gone to the High Court, because all disputes relating to the election of the president, which is a process, not an event, must go to the Supreme Court. And what the Court of Appeal had no hesitation in finding was that what goes to the Court of Appeal is a dispute relating to the outcome. It has to be post-outcome or even in the process, but not that anything touching on the presidential elections goes to the Supreme Court. So the winding up court will not be dealing with the matters that are under Section 12 of the Employment and Labor Relations Code, which sets out its mandate. I see no conflict. One needs to look at the section a little more carefully, but I on the face of it, I see no conflict. I'll hand over to Martin to deal with the why one has to be in physically fine shape, but I see an opportunity for the hungry litigators. You can go to court now.
I think that It's the law, Lillian, it's the law. It says physical or mental. Now, as to what is physical, it's not explained. So it's a question of argument, or it's a question of demonstration. So I don't want to speculate, but I can imagine many things. If you are in the process and maybe you got a disability that makes it impossible for you to operate as a, and I don't know what that kind of disability could be, but it could be physical, it could be mental. So really, it is subject to, it's not complete in and of itself. So it's something that we can keep talking about. The question is that, are you in all respects fit and in a position to be an insolvency practitioner? Of course, if from your side you are saying yes, it is from the side of the person who is alleging that you are not to demonstrate that. So I would leave it at that, Lillian, if that is helpful, but I'm not sure that you may feel adequately answered. There were other issues about, Sally took on and pushed your case. You know, commercial issues, and especially issues that have to do with insolvency, are fairly interesting. And that's why I say that the insolvency practitioner has to be careful, because there will be complaints and there will be reasons for anybody to complain, whether one is acting equitably or whether one is acting partially. Whatever it is, there will be instances. And yes, we've seen it, and it's not likely to go away. We've seen instances where insolvencies have been externally triggered. Indeed, we have seen instances where insolvencies have been forestalled through external interventions. If you ask me, there are two cases going on right now. Uchumi is a public, the other one is Nakumat. Both of them are retail, and one is family, one is heavily public, and it has some external, it has some government resources in it, but the treatment is different. If anything, we want to help Nakuma to quickly shut down. Now, who is going to suffer? Nakumat is not just a retail, a supermarket out there. It's an employer. It is a major economy player, or a major player in the economy. Just like KQ. So just like Kenya Airways, and you can say, but you see government has shares there, fine. Just like Uchumi, and you can say that government has shares there, fine. But when all is said and done, Nakumat is a major contributor to the economy. It is a major contributor. It pays taxes. It generates. So when a major player like that is about to go under, what do? You sit back and say, well, but it's a private thing, so it's not up to us to bail them. Then you go back and ask yourself that when 2008 Wall Street was melting, what was the first thing that the new President Obama then did? Was to put in public resources to shore up the private entities in order for them to recover. And indeed, a lot of them have recovered and have since paid back the money, and they're going on with their business. Some of them have recovered long enough now to take over White House. You know what I'm talking about? Yeah, you know who I'm talking about? Whose executives have now gone to the White House, and just about 10 years ago they were blacklisted, and so on. So basically what I'm saying there is that you know, in this real world, and again for us as lawyers, in the real world there are a number of things that you're looking for. It could be a clear case of business going bad, or it could be a clear case of business being made to go bad. So what do if you are involved in that process? And again, the spirit of the Insolvencies Act is that we are looking at rescuing rather than helping them go to their death. And that's the spirit, really. So whatever you do as an insolvency practitioner, you want to demonstrate that there is every chance to rescue unless you find yourself unable to. Look at the recent case of Chase Bank. The approach was not to shut it down, is even to get KCB come in, help show them back, and see the extent to which that would happen. And I think there's a process there. Imperial Bank, there has been a process there until you reach a point where you say, hey, this is beyond repair. So that's the kind of spirit that the new insolvency law is informing our practice and our jurisprudence. So really, that is a clear thing. Now, I made a statement about the role of insolvency practitioners and the need to forestall successful complaints. And I said that there are certain cautions that one needs to take care of, including meticulous documentation of processes. And the other one that I mentioned is taking legal advice. And the other one that I mentioned was, in special circumstances, ensuring that you seek court's protection or court's interpretation of the actions that you are taking in order for you to have that legal clothing. Now, to that extent, there is nothing wrong. Courts are as much a player in this process. Remember, once you're into insolvency, courts are also part of it, because any of the claimants or any of the aggrieved parties are free to raise issues before the court, and courts can give direction in that matter. So I don't see anything wrong. The only thing I said is that it tends to be an expensive thing, but it is a recourse that one can fall back to, especially if you want to ensure that you are well covered. And I'm sure that anybody involved in this business doesn't want to leave the place with a skunk. You want to leave it better, and you also want to escape it. I mean, to find a way in which you get out of it, in a good way. Now, yes, the likes of Continental, the likes of Kenatco and others have been under receivership for a long time. Now, that was the nature of our law then. Now, of course, we are bound to ask the question, how long can one be in receivership? What is a reasonable period? And I think these are issues of litigation that we can work around. But certainly, the case of Continental, the case of, I think now Rural Urban is closed, and others, cases that are wrong, and especially in the new dispensation, you should be able to, if you were to be given instructions, you can raise issues, and you say, for how long should a company be in a receivership? What are the steps that are being taken to bring them back? But there was a question that was directed to my brother, KK, and essentially, what I said is that insolvency is a process, and unlike the administration of the estate, the insolvency is triggered in the lifetime of a company, a corporate entity. And for that reason, the corporate status of a company remain. And indeed, it is what then holds back after the rescue, once all obligations have been met. Yes, the manner in which the company is being governed is different, because then the role of directors becomes functus officio. But once the exercise of or the process has been ended, then the company's structures assume, and so, or rather, they come back, or they are reinstated, depending on at what point it is. And for that reason, those companies are still legal entities, able to exercise certain obligations as and when they become necessary. So that's something that we can work on. What laws have we put in place to ensure that we do not fall back? Let me say this, and this is why we are in business as lawyers. It's the inadequacies of laws, the shortcomings of practice that makes us relevant. So the only time when we are very active is when bad laws are passed, and when people break the law, and so on. And when the morgue attendant is complaining that the business is slow, you know why. So, yeah, that's how we thrive. Thank you.
Sorry, I missed one question. Thank you, Martin, for dealing with the corporate status and powers. I think it was Joroge who talked about the moratorium. If you look at some of these industries, they've got their own banking, has a Banking Act, insurance has the Insurance Act. That's where you'll find a lot of those. These are not under the Insolvency Act. And the thinking behind that is that you sometimes want somebody coming in to take stock of what's going on in a particular company and determine what steps need to be taken, either to revive the company, engage the previous owners, or engage anybody else for that matter, or whether it should be going into liquidation. I suspect that's something that is going to be with us for a long time, as long as we have these specialist industries, and it's not something that is peculiar to us. The one thing that is peculiar to us is that you have a company having a moratorium for 5-10 years. It doesn't happen in many other jurisdictions. They get somebody in there to fix the problem and fix it quickly. That's what we should be working at. It's not the law that is a problem, it is the implementation of it.
I'm persuaded not to take any more questions because the law of diminishing returns, we are dealing with companies. You have some paper in this kind of color. Please, I want you to rate our speakers. There are 4 of them, Ben, Noella, Martin, and KK. Please, it helps us to know who are the people that we should be calling more often. Please rate them for us and leave the paper behind. I want us to go for lunch, but as you go for lunch, there's a procedure, just like winding up. There are 2 cards there. I don't know who came up with these colors. Martin, you'll tell me. There's a green voucher and a yellow one. Martin, it's not me.
Those are Kamba colors.
If you get a green voucher, please go downstairs for your lunch. If yours is yellow, they've been given there at random. You stay on this floor, Amboseli Hall. So you don't just eat anyhow. So there's a procedure for winding up today's processes. I want to thank all of you for attending. This is very rare, but if you promise to keep coming and staying up to the end, we'll keep on coming to Hilton. Sawa sawa. But if you keep on disappearing and diminishing, we'll go back there. It's not a threat, but there are some times we have more people than we need, than this hotel can hold. But I thank you so much for your concentration, and thank you, and have a nice weekend. All the best. Thank you. Watu wamechoka. Wamesoma ya kutosha.